In a significant and thought-provoking development, the Allahabad High Court has recently observed that a married man cannot be in a live-in relationship without legally dissolving their first marriage. Now, this observation has sparkled a nationwide debate around the right to freedom, guaranteed under the Constitution, Article 19 to Article 22, specifically concerning Article 21, which guarantees the protection of life and personal liberty. Before we understand the decree of the Allahabad High Court, let us quickly get a background of the story so that we could understand the judgment given by the Allahabad High Court. The two couples who were in a living relationship went to the court filing a writ petition seeking the protection from the police, citing that there are apprehension to the threat to their life. Couples were adult above 18 years of age and they were in a living relationship by consent. They were mutually agreed to be in such a relationship. Now, there appears to be no wrong in this relationship because previously the Supreme Court has observed that two adults can be in any type of relationship belonging from any caste, any religion or any gotra. They have the freedom to decide their relationship. What Justice Vivek Kumar Mishra has observed is very beautiful. He said that right to freedom is not absolute but qualified. That means the right to freedom of an individual ends when the legal right of the other person starts. That means that if you are legally married and you are in a legal relationship with your spouse, then you cannot be in a live-in relationship with any other adult, even though you have a mutual consent among yourself. Observe that the petitioner, who were already legally married to their spouses and despite of their legal marriages, they chose to enter into a live-in relationship, their fundamental rights under Article 21 cannot be guaranteed. As the fundamental rights mentioned in the Constitution, that is right to freedom, is not absolute but subjected to the lawful restrictions. Also observe that till the decree of divorce is not obtained from the competent court, the marriage will exist, and within that period, entering into another marriage will constitute an offence under Section 494, read with Section 17 of the Hindu Marriage Act of 1955. The court also provided a remedy to the petitioner, saying that the petitioner, if disturbed or subjected to any violence, can approach to the senior superintendent of the police or superintendent of the police and submit a detailed application to them, and also directed the authorities to do the needful. Now here we have understood that the fundamental rights are not absolute but they are limited to the lawful restrictions. In our fundamental course on Indian polity, we have discussed all these concepts sufficiently. What are the fundamental rights? What are the properties or nature of the fundamental rights mentioned in the Constitution? What is the difference between the absolute right? What are the restrictions on the fundamental rights? What are writ petitions and all other related concepts? The course is available on our mobile application, which can be downloaded from the Play Store. Quickly download the application and avail the course. Thank you.